Hello, everyone, and welcome. My name is Elizabeth Renieris, and I'm the founding director of the Notre Dame-IBM Technology Ethics Lab. Today, we are proud to host this session on the future of rights, a conversation about whether emerging technologies and our evolving relationship to technology are creating a need for new rights. It is widely understood that ethics and morality provide the normative frameworks that underpin what are ultimately codified as substantive legal rights. While ethical principles and frameworks for artificial intelligence and other new and advanced technologies have been proliferating for nearly a decade, there has been considerably less emphasis on the question of legal rights. In this session, we will examine the ways in which new and advanced technologies such as AI, neurotechnologies, ever-ubiquitous smart devices, new human-computer interfaces, and more challenge existing rights, looking at specific and concrete examples of technological applications. We will also explore whether we need new substantive rights going forward, and if so, what kinds of rights we might require now and in the future. We are far from consensus on these questions. While some experts argue that new realities demand new substantive rights, others contend that we need to apply or adapt existing rights to new realities. This session will also explore the extent to which these views actually diverge, or whether there's perhaps more agreement under the surface. Finally, we will explore the implications for practitioners who are designing, building, and deploying technologies, as well as the law and policymakers who seek to govern them. We are fortunate to have an all-star lineup of experts to help us explore these questions. First up, we have Susie Alegre. Susie is an international human rights barrister and associate tenant at Doughty Street Chambers, a senior research fellow at the University of Roehampton, and an associate of the policy practice. She's worked on human rights around the world for organizations including the OSCE, the EU, the UN, and Amnesty International on some of the most challenging human rights issues of the 21st century, including the impact of technology on human rights and counterterrorism, and combating corruption. She has particular expertise in the rights of freedom of thought and opinion in the digital world, and is currently working on a book on the right to the freedom of thought. Next up, we have Andrew Pakes. Andrew is Research Director and Deputy General Secretary at Prospect Union, representing over 150,000 members across tech, specialist, engineering, and professional roles. He leads Prospect's work around tech, AI, data rights, and the future of work. He is also a visiting fellow at the UK's Economic and Social Research Council-funded Digital Futures of Work Research Centre, looking at worker experiences of digital surveillance. A campaigner at heart, Andrew serves on the board of the LGBT equality charity Stonewall. Next, we have Frank Pasquale. Frank is an expert on the law of artificial intelligence, algorithms, and machine learning. He's a professor of law at Brooklyn Law School, a visiting scholar at the AI Now Institute, an affiliate fellow at Yale University's Information Society Project, and a member of the American Law Institute. His 2015 book, The Black Box Society: The Secret Algorithms That Control Money and Information, has been recognized internationally as a landmark study on the law and political economy of information asymmetries. And his latest book, The New Laws of Robotics: Defending Human Expertise in the Age of AI, develops a new political economy of automation in which human capacities are the irreplaceable center of an inclusive economy. Last, but certainly not least, we have Sushma Raman. Sushma is the Executive Director of the Carr Center for Human Rights Policy at Harvard's Kennedy School of Government. Along with former Executive Director of Amnesty International, Bill Schultz, Sushma recently co-authored The Coming Good Society: Why New Realities Demand New Rights, which examines the coming changes to the human rights landscape and argues that rights must adapt to new technological and scientific realities or risk being consigned to irrelevance. Sushma is the host of the Carr Center's Justice Matters podcast, a contributor to Foreign Policy magazine, and a senior advisor to Walbrook, a global intelligence, due diligence, and risk advisory firm. Thank you all so much for being with us today. What is the freedom of thought, and from where does it derive?
Well, the right to freedom of thought, or the idea of freedom of thought, is a sort of historical, philosophical, and political concept that we can see, dating back centuries to philosophers like Spinoza, and in the UK, J.S. Mill, talking about this idea of freedom inside our minds, the freedom to develop our own thoughts and opinions. But what we see then in 20th century international human rights law is that idea of freedom made into a legal right in international law. So first in the Universal Declaration on Human Rights, and then later in other legal instruments like the International Covenant on Civil and Political Rights, and in regional instruments like the European Convention on Human Rights. And so those instruments really set out this idea that we have a right to freedom of thought, which goes along with our right to freedom of conscience, religion, and belief, and is also closely connected to our right to freedom of opinion, which is linked to the right to freedom of expression. And what those rights involve is a sort of two sides to the freedom, if you like. There is an inner freedom, the idea that you can think whatever you like inside your own head. And that part of the right is protected absolutely. And an external freedom, the freedom to share what you think, what you believe, and essentially to express yourself. And that freedom, like the right to freedom of expression, is a limited right, which means that in some circumstances you can limit it. So this idea of freedom of thought is quite a complex idea. And I think one of the challenges in the 21st century is translating that philosophical idea into a practical legal instrument.
Thank you. That is a really comprehensive perspective, situating the right in the historical political context. So really appreciate that overview. So let's dive into the 21st century. How is the freedom of thought under attack or challenged by new and emerging technologies? And could you give us some specific examples?
Well, I think if we focus on the inner aspect of that right, which I think, as I said, it's an absolute right. And an absolute right is a right which can never be interfered with for any reason. So you can't say, there's a security imperative and therefore we need to get inside people's minds. Essentially, that right to think for yourself is protected absolutely inside our minds. And if we look at what's going on inside our minds, there are three practical aspects to the protection of that right. The first is the right to keep your thoughts private, so no one can coerce you to reveal what you're thinking. Nobody can force you to tell them what you're thinking. The second aspect is the right not to have your thoughts and opinions manipulated. So no one can go in and twist the way you're thinking, feeling. And the third part of the right is the right not to be punished for your thoughts alone. Once you act on your thoughts or express your opinions, then you're in a different territory. But while those thoughts remain inside your head, no matter how dreadful those thoughts might be, you can never be punished simply on the basis of what's going on inside your head without actually taking any action or expressing those thoughts. And so if we look in the digital age at how those practical aspects of the right might be affected, I think one of the really useful prisms for looking at it is through behavioral microtargeting, particularly in the political context. So if you look at, for example, the Cambridge Analytica scandal, this idea of what was being sold with behavioral microtargeting in political campaigns was the idea that a company can get insights into how you're thinking and feeling, understand your personality based on your Facebook likes or based on large amounts of data about you, or even metadata about how you're behaving online. So not looking at the fact that you might have said, I'm going to vote for a political party, but just assessing the way your personality works, the way your mind works, based on the way you've interacted with posts. So not on your expressions, but on the way that you're interacting online. And to use this assessment of your personality then to tailor and target advertising for you as an individual that will potentially make you either decide to go out and vote or make you decide to stay home. And so if we look at that that loop, the first idea of profiling people based on their interests or based on their activities online and their personality traits could be seen as really getting inside the mind and trying to understand or infer your thoughts and feelings without you actively expressing them. And as I say, it's not about you making a post to say, I'm going to vote for this person. It's much more subtle than that. And then the second aspect, this right not to be manipulated, is where you're unaware of the nature of targeted advertising that is being sent to you individually. So it's not being sent to your neighbor, it may not be being sent to your friends and family, but based on this assessment of your personality, it may well be that the tone or the angle of advertising that you're being sent, which may not even be clear that it is advertising, it could just be messaging that you're being sent, is being used to manipulate the way you think and potentially to behave. And what I think is important about this as well is the subtlety of it, that whether or not it actually worked in practice, what was being sold was this ability to understand and then manipulate how people think and therefore behave. Not to switch someone from voting Democrat to voting Republican, but essentially to identify which people are going to vote in favor of your client, which people aren't, and then potentially to affect whether or not they decide to go to the polls based on how they're feeling that day. And what we've seen in experiments from Facebook, coming out of Facebook and researchers working with Facebook, is this idea that, you know, on the one hand, Facebook may know you better than you know your friends based on analysis of your activity on the site and your likes, not your posts in particular. And secondly, this idea that your newsfeed can affect how you feel and therefore how you behave. And there was a mass social contagion experiment carried out controversially by researchers with Facebook that showed that simply by tweaking the order that information is delivered in, that Facebook could affect how people were feeling that day. And if you think about that on an election day, how you feel might well affect how keen you are to go out in the rain and cast your vote. It may also affect how important you feel your vote is going to be in the context, given the information that you're being given. So again, it's not about twisting someone's political views entirely. It's much more subtle than that, about affecting how you may be feeling on a particular day, on a particular time. And that's, you know, that operates in the political context, but it's also the basis for advertising technology more broadly. And then if we look at the third aspect, the right not to be penalized for your thoughts, again, these kind of inferences that are being made based on whether it's on social media, big data, metadata, inferences that are being made about people's personalities, we increasingly see in the security sphere, risk assessments and risk analysis, identifying whether or not people are risky or potential criminals. You know, we've seen a real growth in academic research that is going back to wholly discredited modes of deciding whether or not someone's a potential criminal simply by analyzing their face. But it's not about their face, it's about what people want to think they can infer about what's going on inside their minds from their face or from their data. And that happens in the criminal justice sector, but it's also happening on a daily basis in terms of the kind of opportunities that people have.
Yeah, it's interesting. Those are quite tangible examples that a lot of people are now familiar with because of things like Cambridge Analytica and because of some popular films that have come out recently. And there is a lot of discourse around these topics, but what we see often is that the perspective or the entry point is a conversation around things like privacy or the freedom of expression. And we don't really hear as much about the freedom of thought in this discourse. So, you know, in your view, why are these other rights like privacy and freedom of expression insufficient to protect us in the digital age? And why do you think we're not hearing as much about freedom of thought when we talk about digital rights?
Well, starting with the second point, I think one of the reasons we haven't heard about it was that when I first started researching on the right to freedom of thought, which was when I first heard about Cambridge Analytica, and I felt that privacy just didn't really get to the heart of what the problem was. I'm like, well, you know, yes, there are privacy issues, but that's not the heart of the problem. The problem is about somebody saying they can get inside my mind and move the furniture around. And that to me is about this freedom inside my mind. But when I first looked at it, it was very clear that although, you know, the drafters of international human rights law had made it very clear how fundamental it was, they also in some way tacitly accepted that, yes, it's fundamentally important, but in practice, no one can get inside our heads. You know, the governments can't get inside our heads, so we don't need to worry about it. We have it here because it's so fundamental to our humanity, but we don't really need to worry about it too much. And I think that is why the right to freedom of thought had not been developed so far. And this idea that it was some sort of philosophical idea rather than a concrete thing that you needed serious practical protections around. So why I feel then that freedom of expression or privacy aren't quite enough? Well, as I said earlier, the right to freedom of thought is an absolute right. And there are very few absolute rights in international human rights law. You know, we have the prohibition on torture, we have the prohibition on slavery, and we have this right to freedom of thought and freedom of opinion in the forum internum. And if you think about all three of those absolute rights, they have similar qualities. One is that all of them are absolutely fundamental to what it is to be human and to our humanity and our dignity. And the second point is that once you lose them, it's incredibly hard to get them back. They are things that are so destructive that there's no legal cure. Once you've lost it, it becomes incredibly difficult to claw back our humanity and our dignity when there's a violation of any of those rights. And so when we look at the right to private life or the right to freedom of expression, you know, those rights are more standard limited rights. And the reason for that is because of the way they interact with other people, the way they potentially affect other people, the way they potentially affect our security. And so you get a debate about balancing rights, if you like, or, you know, where the boundaries of those rights need to be and the legitimate justifications for limiting those rights. And particularly when you look at freedom of expression and privacy together, you know, one person's privacy is another person's freedom of expression. You know, if somebody wants to talk about someone's private life or, you know, publish things in the press about someone's private life, you can see a clash between those two rights and you see how balancing rights work. But when you're talking about this freedom inside your head, it's something where quite simply, if a practice is an interference with that right, it will never be acceptable. And so that really goes to the heart of particularly the surveillance capitalism business model, this idea that our data is being used to try and understand how we think and feel in real time, and use that to predict how we're going to behave and to nudge us in different ways and influence how we behave. That whole ecosystem is premised on getting inside our heads. And so if that ecosystem really is a violation of our right to freedom of thought, then that has to change urgently. And that is wholesale violation of the right to freedom of thought.
Yeah, it's quite an interesting point about the sort of drafters of some of the international human rights law instruments sort of taking for granted the inviolability of the fora internum, and how they wouldn't have foreseen some of the threats that are emerging. I think about this more and more in the context of things like brain machine or brain computer interfaces and neurotechnologies, and a whole host, an array of technologies that are emerging that are sort of penetrating these boundaries, this boundedness, this border between the sort of internal and external. How do you think the freedom of thought could be adapted to those technologies in practice? And could you perhaps give us some examples?
Well, I think those technologies, as you said, the brain-computer interface is just so clearly a problem waiting to happen in terms of our right to freedom of thought. And I remember when I heard it first announced, the Facebook version, that there was a sort of, well, we'll be able to read your thoughts, but of course only the thoughts you want us to read. And you're thinking, yeah, of course. How exactly are you going to police that? How are you going to, indicate which thoughts you want to share and which thoughts are just intrusive thoughts that are flitting across your mind? I think what these kind of developments really show is how important it is to adapt and use the precautionary principle in terms of tech innovation and tech development. So that is the principle that, you know, where scientific developments could have really substantial impacts on our human rights now and in the future, then they should be either stopped or proceed with caution while you assess what their potential impact is. And I think looking at this right to freedom of thought and particularly its absolute nature, gives a really useful prism for looking forward at tech innovation and deciding which developments we want and which developments really we should be very cautious about.
There is so much subtlety embedded in this analysis and in the application of something like freedom of thought. And one of the most challenging subtleties that I perceive is where to draw the line between something like manipulation and persuasion, or a question about whether the ends matter. So, for example, one of the reactions we've seen towards surveillance capitalism is this movement around sort of beneficial tech or humane tech, or tech directed at more noble ends, if you will. Does it matter in your view whether we're being, nudged towards something good or sludged towards something bad for us, or, who should even decide these questions?
Well, in general, on the second point, I don't think it really matters if we're being nudged towards something good or dragged towards something bad, because as you say, who's to decide what's good and bad in any particular context? And similarly, this idea that there can never be a justification for interfering with the right to freedom of thought means that you can't just justify it on the basis that you're going to make us all better, healthier, happier people, unless we are voluntarily consenting to something that we can understand. And I think, consent is really crucial to this idea of what is manipulation, what is persuasion, but it has to be informed consent. And so it's not a hitting a consent button, accepting all cookies. That is not realistic consent for what we're looking at. In terms of that line between manipulation and persuasion,
let's begin by discussing how existing rights frameworks are falling short. So, Andrew, at the start of the pandemic, the shift to remote working was seen as the potential start of a new era of more freedom and flexibility around when and how we work. But instead, we've seen a proliferation of commercial surveillance and monitoring tools that promise to gauge things like employee engagement or productivity. And even before the pandemic, digitalization was blurring the lines between our working and non-working lives, making it harder to switch off or unplug. How effectively or ineffectively do existing employment laws and regulations, or laws and regulations generally, address this phenomenon, whether in the UK or elsewhere?
Yeah, well, I think, the experience of the last year and the COVID crisis has transformed our understanding of the power of technology, how digital means for many of us has kept us safe, connected, still working, whether it's remotely at home. But it's also revealed this other underside you've spoken about around the growth of surveillance, what it means for privacy, the whole idea of consent and the intervention of technology into walks of life we'd never considered before. So we were already, as a trade union, looking at this blurring line between home and work way before the crisis happened. The inversion of our working lives for many of us over this last year has just put that into sharp relief. And for me, it raises a number of issues. It raises issues around privacy and whether that is effective for us. The whole idea that what's perhaps been acceptable about technology in the workspace or in an office or in a factory, suddenly cameras and employers are coming into our private lives, into our homes. So I think the whole concept of privacy rights is changing in terms of, we always used to say, if you have a bad day at work, go home, shut the door and put it behind you. We're now bringing surveillance, employers, the work pressures directly into our living spaces. And I think that's a fundamental challenge. What does privacy mean if we're remote working or working from home? Secondly, most of the employment laws we have and employment rights we talk about just about anywhere in the world are largely based on the experience of work in the last century. This idea of managing physical harm and physical risk. So the idea that, factories, we have limited working hours, we have protections against physical accidents, we have liabilities for employers to keep us safe whilst we're at a work facility. I think that's changed now that we're moving into a data world. And what does that mean in terms of data rights, about intangible things, the ability of algorithms or machines to make decisions about our lives in a way that we can't quite see or feel in the way you could do if someone had an electrical accident in the workspace. We can understand that. Wires shouldn't be out there. What does that mean in this cloud-based kind of world around that? And then really finally on this, I think what it really brings to me is the intersection between individual rights and collective rights. And I think that's really important, because what the pandemic's shown is that my health status, as whether I have COVID or not as an individual, is also part of collective idea, because it's about how I could infect others, how others could infect me. And that really brought into definite relief this idea that individual data and individual rights is important, but it's not enough, not sufficient to look at the collective impacts our use of data could have on us.
Brilliant. Thank you, Andrew. We'll definitely turn back to this distinction between individual and collective rights as we think about a path forward. But speaking of algorithms, I'd like to turn to Frank, who's obviously written extensively about algorithms. So just as digital technologies have blurred the lines between our personal and professional lives, advances in automation are changing the nature of interactions between humans and computers. And once the object of science fiction, robots are quickly becoming a reality in the modern commercial landscape. Frank, your latest book is called The New Laws of Robotics, Defending Human Expertise in the Age of AI. Can you please walk us through some of the challenges posed by an increasing reliance on robots and automation across healthcare, education, financial services, and a variety of other sectors, as well as why you believe that existing legal frameworks fail to adequately address these challenges?
Well, thank you, Elizabeth. Yes, I think that there are a number of challenges that are either currently being faced or that are on the horizon. And just to have a nice segue from some of Andrew's points about the idea or the problems that arise in the workplace, I think that the problem of the algorithmic manager is high on the minds of many workers, particularly in the gig economy now. The idea that everything you do can be continually monitored. And there are some contexts where we might want to see more monitoring. For example, I know there's been very interesting writing about the role of monitoring in nursing homes or in areas where we need more care for the vulnerable. But we always have to be aware of trying to balance that with some basic rights, maybe to be not watched, or rights to a certain level of personal space and integrity. And so I think that's a major concern I have, is that one of the smaller forms of freedom that many of us have known, as workers, is the inability of a supervisor to continually watch what one is doing. But when the supervisor is sort of replaced by a camera, that's very different. I think also there's in terms of databases and in medicine, there's some wonderful opportunities on the horizon in terms of new diagnostic tools, new abilities for machine learning to supplement the work of dermatologists, radiologists, pathologists, and others. But there is, of course, the shadow side of that is the worry that these types of systems are not going to adequately represent populations as a whole. And so that leads to another potential right, a right to be represented. And it's something that is not only an algorithmic issue, I think, but also is a right to, is something that comes up in the context of DNA databases, other types of very large big data projects in order to better help individuals with healthcare. And then finally, I guess with respect to education, there was a recent very interesting controversy and troubling controversy in Britain about the off-qual and the testing that was done there of a lot of students, and the failures of an algorithmic effort to adjust test scores in a pandemic setting to pre-pandemic settings. And the crudity of that algorithm led, I think, a lot of students to call for, I mean, they used very colorful language, but which I could not use here, but I would style their complaint as something that Danielle Citron has called technological due process. The idea that one has the right to some level of human intervention, review, or appeal when one's is evaluated by an algorithmic system. So I think if we put all these together, rights to representation, to autonomy, and to fair review or due process, they could be a really formidable way in which individual interests in human autonomy could be vindicated by new legal systems.
Thank you, Frank. It sounds like we're all in agreement that technological developments are threatening and challenging the application of existing rights. Susie, of course, argued that it's not so much that we need new rights, but rather that we need to reinterpret and apply existing ones more effectively, such as the freedom of thought. And she gives the example of why the freedom of thought may require that we outlaw certain manipulative practices like online behavioral advertising. I'd like to turn to Sushma. Sushma, you recently co-authored a book subtitled Why New Realities Demand New Rights. From your book, it seems that you would agree with Susie that we need to reinterpret existing rights, but you also take it a step further and argue that the current moment requires an expansion of rights to include the introduction of entirely new rights. In your view, how do we need to expand our thinking around the rights that we require vis-a-vis emerging technologies? And how might these rights apply in practice? And perhaps you might give us an example or two.
I do believe that while we've made significant progress due to technological and scientific advancements, even in the past year alone, if we think about the progress made in developing vaccines and disseminating them, the ability of many of us to work in the remote world, there's been significant progress due to technology and science that we have benefited from, and including progress in the human rights domain, such as the use of technology to, for example, identify, victims of war crimes or trafficking victims and so on. But the reality is that new and emerging technologies are increasingly being used by governments and corporations to surveil individuals and communities, curtail rights and freedoms, and could result in greater inequality. Tools such as facial recognition are being used to target activists, journalists, social movement leaders, members of oppressed communities, and so on. And of course, this rise of the technology-fueled gig economy has significant implications for the rights of workers. We're seeing AI-powered tools in everything from criminal justice to asylum processing, leading to errors, but also reinforcement of racial and other forms of bias, vast data gathering on vulnerable populations. And these all raise questions about how best we secure algorithmic justice in a digital age. So there are, of course, implications for the right to privacy, but a range of other rights and freedoms, freedom of not just thought, but also expression, assembly, association, and implications across the entire range of human rights and indeed the human rights framework. The question then becomes, do we need new rights or do we just need to adapt existing rights to meet this current technological era? And I believe that we would probably need to do both. Many of the issues upon us we have identified, but there's much that is still unknown. And so I think that we need to be open and flexible. And part of what Bill Schultz, my co-author, and I argue in our book, The Coming Good Society, is that rights are not necessarily static. Although we have this framework that was developed 70 years ago, we might want to think about how do we adapt existing rights, such as the right to privacy in this current era, but then we might think about other forms of rights as well. For example, the ACLU and the Electronic Frontier Foundation have championed the right to record in context of police abuse or violence so that we have documentation to hold state actors accountable. So my recommendation would be that we not be dogmatic or rigid, but that we really think about how we can adapt rights to ensure their relevance, effectiveness, and impact in the coming decades.
Thank you, Sushma. And along the lines of the types of new rights that we might need, one of the sort of reinterpretations that Susie points out in thinking about the freedom of thought in the modern era is around the fora internum and the sort of right to protect the boundedness of the internal space. It actually feels very similar to a new style right that Andrew, you and some of your colleagues have been working on in calls to enshrine a kind of right to disconnect in legislation in the UK. And we've also seen similar proposals for a right to unplug in Europe, and it comes by different names. And some of these proposals have been criticized as being infeasible in a world where, work hours and practices are increasingly non-standard, very hard to define when a workday begins and ends. Could you please elaborate on what a right to disconnect might entail and how it would apply in practice, including how you might respond to some of these critiques about the feasibility of such a right?
There's a growing movement around the world as we come out of this pandemic where workers and worker organizations are beginning to realize that this, the tale of this digital world can be both positive and negative. And it's how we have that conversation. The evidence of the last year in the United Kingdom and other countries I've read about is that whilst many of us have been working remotely on laptops from kitchen tables or spare rooms, and that's had positives, the working days got longer. The pressure on people to always feel like they need to respond, the ability of what some of our Australian colleagues call the digital leash, kind of connecting us so we can't come out about it. There's other writers have talked about, the tyranny of emails. I think there's a cultural perspective about how we want to feel connected as citizens and individuals, but actually that creates a culture in the workspace, particularly because it's a contractual work relationship, either as a freelancer or a worker, where you are obliged to respond. And that pressure for workers to feel, checking my phone first thing in the morning, checking it last thing at night. If my boss says something, do I need to respond? And there's a kind of pressure point around that. And I suppose to me, this whole right to disconnect movement has been around how do we have those conversations as workers and how do we have them in society as a whole? And there's different models. You've got very much a French model, which I think is very much interesting. They've had laws pre-pandemic which obliges all companies of 50 employees or above, so traditionally medium or large size employees, to have an annual negotiation with their workforce, either through unions or works councils, something much more common in the European tradition than the US tradition, but setting the sense that there needs to be a requirement on employers to have that conversation and set the boundaries for it. In Ireland, at the beginning of April, they had a more prescriptive approach, which again sets out some of the limitations companies need to understand. And just in the same way we have health and safety rules around the world, this is like a digital health and safety rule. Yeah, and very much the conversations we're having with companies and governments is how do we get that right? So in Europe, you've got companies like Telefonica and the telecoms company. Renault, the car manufacturer, has just signed a global agreement with its works councils and unions, which sets out the rules on teleworking, but also on this idea of a right to disconnect. And every job is different. If I work in a supermarket, my job is different to working in an office or working in a factory. So we'd like to see a right to disconnect, which involves workers having a negotiation with their employers that says, I'm willing to work, but actually, if it goes beyond what is expected, then either you pay me to do that work or I don't work.
Our relationship to work is changing. And to go back to the point around robotics and automation, it almost feels as though humans are being held now to robotic standards, right? Or to sort of machine-like standards. Frank, I think I've seen commentary from you on this point before, but would you like to respond to Andrew's points or to elaborate on how this relationship is impacting our rights?
Yes, I really appreciate Andrew's points about this right to disconnect. And I think it's about, and I think that framing it as a right helps change the culture, because I think sometimes when people try to challenge it as being unworkable or, a barrier to efficiency, et cetera, I don't think that's necessarily the case. I think that really we need to learn more about different ways of working and ways of working that enable people to have a certain barrier or some separation between time at work and time at home. From an ethical perspective, I'm always reminded of like Michael Walzer's idea of separate spheres and sort of this idea that, part of if all of one's experience is sort of dependent on, work or how much money one has or one's other place in society, that is really oppressive and tyrannical in many ways. And I think that with respect to automation, I'm really inspired by Frischman and Selinger's book, Reengineering Humanity, which, really is I think quite eloquent in talking about how the pressure to perform constantly and in a very within a very narrow range of affect and timelines can also be oppressive. And there I'm particularly reminded of, I published a piece in a magazine called Real Life on affective computing. And I think that what's striking to me about affective computing is that it is marketed as a way in which AI and machine learning can assist computers in decoding individuals' emotions, how they're feeling, and trying to promote certain feelings in individuals. But the problem that I have is that, if you have that type of technology, it can create new responsibilities for workers to ensure that the customer or whoever the target is manages to expresses some level of like approval or happiness or whatever it might be under the affective computing system. And I'm particularly reminded of that by, people that I've known that have done call center jobs where they've been monitored and, looking at some of the work on call centers. And, if you throw into the mix, not only, the understandable performance metrics, but also potentially inexplicable performance metrics that are based on a machine learning system analysis of the level of satisfaction in the customer's voice. This, I think, is also something that really is crossing a line. And the line it's crossing is not necessarily the level of alienation one might feel from a machine being assumed to have, or promoting machines as human equivalents or partners of humans rather than the tools of humans, but also of human beings being made to measure their own expression, their own forms of communication against automated measures of their value. And so I think that those are all really important issues. And my final recommendation, by the way, would be for anyone watching to see the film Sleep Dealer, because this is a really brilliant film, I think, sort of portraying what it would be like to have a future where a huge amount of work is being mediated by machines that could do all of the sort of surveillance and control that we've been talking about. So thanks.
It's a great film, and from what I've seen as well, it's really showing how much of what is done by machines is actually done by humans, right? And building on a lot of the scholarship there. So I think this introduction of a new right, whether it's the right to disconnect or unplug or however it's conceived, is certainly something I think is gaining traction for the reasons we've discussed, that there are lines being crossed. They're qualitatively new elements of the current environment and our relationship to technology. But I've also seen a lot of critics of this more expansive view of rights and the idea of a more expansive view of human rights, whether it's adding new rights or reinterpreting existing rights. I'd like to turn back to Sushma on this point. Sushma, you wrote extensively on this in your book, and I think also acknowledge that there are some who say having too many rights would either threaten existing ones or dilute their impact. Some are arguing that rights are entirely the wrong framing for technology governance. Why do you believe that human rights is the correct framework for continuing to negotiate our relationship to technology going forward? And how do you respond to some of that criticism?
Thank you so much. That question has many sub-questions, which could take us quite a while, but I'll just say that in the decades past, economists came up with the gross domestic product as a way to assess the progress of individuals and communities and societies. So they measured it by this economic marker. And I think we are currently in an era where there tends to be a technological solution for everything, where people think that if you invent an app or if you come up with a technological product, it is a solution. And I think what the human rights framework brings is a perspective of those who are most marginalized, most excluded, to really think about who is most affected by these technologies, where are the harms, both individually and collectively, and how do we center those perspectives in the solutions that are developed. So that's, I think, one very, very important perspective that was valid 70 years ago, is even more relevant today. I also think that this notion that rights are somehow either not relevant or not impactful is really something that has been developed and spread by various folks, both, for example, you have attacks on rights by authoritarians, and they've never been interested in protecting people's rights and freedoms. And I think as we see currently around the world, the rise of authoritarianism, particularly elected ones, we need to be even more vigilant and ensure upholding the human rights framework. I don't personally think that expanding rights makes them diluted. If anything, it makes it more relevant, because we are ensuring that they are adapting to the current situation, which is very, very different than things that were happening, 50, 70 years ago. I also think that, there is a need for the human rights movement to take stock and to assess what has worked and what has not worked, and ways we can adapt and look to the future. And I think on that front, the human rights movement and organizations need to think about how to better embed human rights values and principles within their own organizations. So protecting labor rights, protecting the value and rights of women who are working in organizations to ensure freedom from harassment and so on. So that, I think, is extremely important to ensure that human rights organizations remain relevant in the digital age.
I think we've mentioned, the need for some new substantive rights, potentially the need to reinterpret existing substantive rights. But I want to talk more about the procedural elements, because it strikes me that a lot of the individual rights we have been unsuccessful in the digital realm because we're not perhaps collectively negotiating them. So maybe I turn back to Andrew on this point as to how you see that balance and the more procedural dimension, and in practice, what you think that means for how to really effectively address these questions of disconnecting or unplugging.
I think the human rights frame is really important in this. To me, it's about fundamental rights, isn't it? I think it's how do we have meaningful conversations around something which feels to many of us as though it's just out of reach. Technology is moving so fast. The ability of AI and other automated means to transform our world almost seems so enormous to most of our daily experiences. So I think anchoring something back in this idea of human or fundamental rights allows us to say, look, let's step away from this and then reapproach the conversation based on what works. And I think that's where the challenge needs to start to come from. I always think there's this wonderful film that I imagine many people have heard of called The Wizard of Oz. And I think sometimes with technology, we regard it as though it is the wizard. And actually what we need to do is turn to the corner and pull the curtain back and deal with the reality of what's actually happening, and not be mesmerized by the kind of the wonders of technology. Actually, this is about, in the workspace or as citizens, it's about how technology relates to us as humans. And we often think about how we relate to technology, which I think is the wrong way around. And I think the human rights framing does that. So I think there's, we always say as a labour union in this, how can we use existing laws as they exist? So for us in Europe and the United Kingdom, we have GDPR, we have equality laws, which allow us to bring in some of that. In the UK, we have an Equality Act, which sets out some of those fundamental rights for us, which gives us one frame for it. We've then got things like health and safety laws. We've got other things which give us, I think it's this big power now of technology. When you put together some of the ability of this technology to take individual bias with the power of a work relationship creates potential for new forms of discrimination in the ways we haven't seen. It's that combination of technology and power. And I think particularly again for the work relationship, it's the ability of this technology in a market-based capitalist system can create an institutionalized way, which is way beyond individuals around it. And that's why, when you see some of the racist or sexist outcomes from this thing, yes, it affects individuals who are concerned, but it will affect people because of the group they belong to, not just their individual rights. And that's why I think that bigger framing comes for it. For us, I think some of the solutions are, in something that's fast moving, is this idea of collective data rights. The collective ability in workspaces. If I am surveilled, it's not, rarely is it me as an individual worker, it will be me and co-workers together. And I think it's that fundamental lens of the impact on me as an individual with that bigger thing. So we'd say, and actually, if you look to things like, some of the, OECD and other bodies, collective bargaining. If you had greater levels of collective bargaining in workplaces, you'd have these conversations happening between employers and others. And just in the same way you've seen the rapid growth in wage inequality, that is because there has been nothing mediating the work relationship. So to me, this idea of how can workers mediate and level that power that technology gives to employers has got to be part of the way of how we bring this together and how we make some of this happen. And that's where we get into the right to disconnect and others. We can approach it from this sense of worker experience, then we begin to change the polarity of the way some of these conversations happen. At the moment, coming out of this crisis, so much of this seems to be about how technology can be done to workers, how facial recognition or other technologies can be done to citizens. And I think the rights framing or the collective framing begins to change that back. What does this mean for us in terms of us as citizens of a nation or a place? What does it mean to us as workers? And I think if we can inject that into the conversation, we have a much better way to kind of think what are the rights and responsibilities of each of us, depending on the sphere of activity we're involved in.
Thank you. I do agree that it strikes me that a lot of where we've gone wrong is really just this singular focus on the technology, right? Starting from the technology rather than starting from the society that we want to live in or the nature of our relationships to one another. And it does seem that human rights move us away from this sort of focus on technology, lift the veil, and really examine, what's going on underneath and the systems that are sort of resulting in what manifests in these technological dystopias that we continue to observe. Frank, the way that I see this in your work is your emphasis on political economy, which strikes me as another way to sort of redirect the conversation away from this technology-centric focus. At the same time, in your new laws of robotics, it's quite interesting to me that rather than focusing on what robots can or can't do to people, you focus on the obligations of the people and the organizations who are designing, building, and deploying robots or automated tools. So framing this issue as laws or obligations rather than rights also strikes me as interesting in this conversation. Perhaps you could elaborate as to whether you believe the challenge for technological governance going forward may actually have less to do with rights in some ways and more to do with the obligations of entities, or whether you view those as two sides of the same coin, and perhaps elaborate on why the shift might be necessary.
Well, that's a terrific question, and I think to contextualize it, I just want to step back a bit and give some praise to the human rights frame, and think about like the human rights frame, the obligations frame, and a potential economic frame and a political economic frame. So I guess there's 4 different frames that one could discuss. But to me, one of the things that I think is most important about human rights framing is that it is, to me, a backstop or a handhold or a foothold against total economization. Right? If we were to just make decisions on the basis of utilitarian maximization of efficiency or the greatest amount of resources to be created by an economic system, all sorts of practices, customs, protections that we take as vital would just go out the window. And so that I think is really important to emphasize that and to think about the inner dynamics as to why that happens. One example I would give there, by the way, is like if we think about privacy as a right and how that has evolved over time, from a purely, say, contractarian perspective, we can say that, well, people consent to being surveilled, they consent to give up their data, and who is the state to stop anyone from consenting to giving up their data, right? No matter how big the amount of giving up might be, someone might agree that to get a 2% lower rate on a loan, they'll allow the loan company to have access to all of their cell phone data for the rest of their lives, including like who they call, recordings of the conversation, all these sorts of things. Like that could be seen as framed from an economic standpoint as entirely efficient, right? Because they're paying less for the loan and the company gets all that data. And it could be framed as, from a purely individualistic contractarian perspective, the person's rights, under a Lochner type of understanding in U.S. Supreme Court law or U.S. constitutional law, one could say, well, who is the state to stop someone from agreeing to give up all of their data to a certain company in order to get that discount rate on their interest rate, or discount on their interest rate. However, I think when you bring in human rights and when you bring in political economy, what you start seeing is first that as soon as you have a few people, as soon as you get a critical mass of people who are making these deals, that creates pressure on other people in society to participate, right? Because if you're not agreeing to this incredibly invasive surveillance, people are going to say, well, what do you have to hide, right? The more accustomed people are to giving up that data, the less socially acceptable it is to be the person who holds out. So that's sort of a dynamic that has been described by Robert H. Frank, an economist, and others. And then I think that sort of thinking about further from a political economic perspective, it's about power, right? So it's like, and that's where I think that we've gone sort of fundamentally wrong in how we even conceive of privacy and data protection online as questions of consent, or at least the jurisdictions that do have gone wrong. Because the power of the company, you need to use certain of these companies. And even if you could find alternatives, you can't really do a lot, or you may have huge sudden costs. For example, you've sunk a lot of effort into Googling in the past and it sort of knows you well, et cetera. And so that sort of recognition, I think, of the collective dynamics over time, of power asymmetries, those are the 3 things that I think that the human rights frame and the political economy frame bring in that are lost if we see the question as merely being one of consent and efficiency. So it's fascinating to sort of see how these very broad frameworks, have really direct implications for how we conceive of the legal problems and the social problems we're facing in the midst of automation and increasing demands for data.
I think this point about the backstop against total economization is a really critical one. And I would agree that human rights and also the political economy analysis are crucial to that. Of course, our lab is very applied and practical in nature. And there are many who would argue that we could turn back to the technology and look at things, for example, like design and thinking about outcomes. So we saw recently that an update to Apple's operating system requiring opt-in consent to tracking across apps has actually led to a pretty sizable shift in consumer behavior around opting in. I think the estimate is around only 4% of people using Apple devices are now opting in to tracking. Do you see any role for design, appreciating that the conversation is bigger than that? But for example, if we have designers tuning into this, are there elements that you see in your respective areas that would be helpful? Andrew, I'll turn to you first. We've seen some critiques about how we never negotiated collectively to have things like text messaging or notifications or these kind of invasive tools. Have you seen any promising sort of design elements or developments that might help with something like unplugging or disconnecting?
I think we very much approach it from let's make this about a human in the loop. So where decision making is made to ensure that we understand who the decision maker is, and it comes back to that framing of whether technology is itself, responsible for its decisions, or is it commissioned or someone. So in a work environment, we'd talk about who has procured the software. What liability they have. And the reality for many companies across the world is that most businesses are not going to be big enough to design their own app. They're not going to be big enough to bring in their own processes for lots of this. And and there's very much a distinction, lots of distinctions here. So the area I focus particularly on is the ability, where technology is used to manage us, or people analytics, it's someone's called, that kind of HR process of technology. Most companies in the world will not be building their own systems around that. So actually they are buying in software which is produced elsewhere. And to me, that raises that question of liability in this process. Who is liable for it? And already we're seeing case law or things coming before tribunals or the law in the UK and Europe, where companies will say, well, actually, that's not my responsibility, that's my supplier's responsibility. So you begin to see this almost data chain of where does liability lie, who has responsibility. So in terms of that negotiated process, we would always say that someone at a company level has to be responsible for the decision-making process. And if they don't understand it, then that's not the problem with the worker. The burden has to fall back on it. Similarly, we have this concept in the GDPR rules, which is the burden is on the employer to demonstrate why they haven't done something. It's not on me as an individual to say, I have, to provide evidence of why my data has not been used well as a consumer or as a worker. The evidence, I can say I don't believe it has, and the company has to put the burden back again. The same regime exists in most health and safety regulations around the world. Companies have to have someone who says, we have considered the implications for this and we are responsible for it. If it turns out they haven't, the liability still exists with them in most health and safety regimes as being the responsible persons or people who have signed something off. And I think following that trail of decision making, particularly where there is a power relationship and that asymmetry that Frank said about, gives us a space. Well, actually, if there is an asymmetry of power, then the burden should be on the people who have greatest power in this relationship rather than those who have the weakest set of power within it.
Thank you, Andrew. That strikes me actually as really practical, right? In the sense of how to operate, how an entity needs to operate and sort of obligations they need to take on. It also reminds me of a comment Sushma made at the start around this increasing use of technology for oppressive purposes, for sort of discriminatory and inequitable ends, the use of AI tools in criminal justice and other contexts. Sushma, I'm curious whether you think that there are design elements that might move us away from some of these oppressive uses of technologies towards a more liberatory imagination. I think about Dr. Benjamin's work, and whether you think the human rights frame is actually a practical part of that shift in the sense of centering a different perspective.
Yeah, and before I answer that question, I just want to make one quick point, because the reality is that over 60% of the world's employed population works in the informal sector. So when we talk about concepts like the right to disconnect or the digital leash, which may not apply to individuals like that who are largely working in the global south, we may be tempted to dismiss many of the concerns that have been raised in these discussions and other discussions as not relevant for many societies, but nothing could be further from the truth. An article that just came out recently by BBC talked about the use of AI emotion detection software tested on Uyghurs in China. And this connects to your earlier point about the connection between individual rights and collective rights that are being violated. And basically what is happening is they are testing whether individuals are experiencing certain negative emotions, such as anger or anxiety, and then people are physically detained or tortured based on their responses to the software that is inflicted, this program that's sort of inflicted on them involuntarily. So just a point that this is something that affects people, around the world and is really, really pressing. So in order to think about how do we design technologies, I would love to turn to a concept that a colleague of mine at the Kennedy School, Sheila Jasanoff, introduced for gene editing. And she talked about the need for a global observatory for gene editing, which would be an international network of scholars, organizations to really promote dialogue in the public sphere about the many ethical and rights implications of these new technologies. And so I would suggest some sort of approach like that would help in thinking about not just the design, but also the deployment, the dissemination, and also sort of the data retention practices for these new technologies. And if there are platforms where you could bring together researchers, scholars, philosophers, ethicists, but also human rights activists.
We probably have time for one more question. So I'll turn to Frank with one that's a question we continue to get through our community and our networks, particularly when we introduced the prospect of this event, which was whether robots should have rights. So in Sushma's wonderful book, I know Sushma asked the question of whether rocks should have rights. And we certainly know that there are jurisdictions looking at sentient beings, animals, natural features. But certainly this question around robots continues to come up. So Frank, if you would, please help us understand how you think about this question.
I'm very worried about where it's going, because I think that essentially, if you look at the rights talk around certain AI and robotics, for example, it's been discussed a freedom to speak, say, and you can imagine that if bots have freedom of speech, or if there are even norms developed on online platforms that are sort of, say, quasi-constitutionalized, as say under the Facebook Oversight Board, of anonymous bots being able to speak, I think it can very easily both deceive people and overwhelm human speakers. I can tweet on a good day, I could maybe come up with 20 tweets, but a bot could probably do 100,000. And so, so that really worries me. We also see, concern, and so that's one worry. I have worries about bots having, say, robots having right of way on sidewalks. That to me, I already feel somewhat stressed out crossing the street in New York City amidst all of the driving, and I don't really want to have to contend with a sidewalk bot that I'm supposed to treat like a human being. I find that really kind of disenchanting and troubling. And I had to cheer on the people who I think there was a robot deployed in San Francisco to push homeless people off of a parking lot. And, I was very happy to see that people resisted it and actually smeared barbecue sauce, of all things, on its sensors to try to avoid being overwhelmed by that. Now, should we live in a world where smearing barbecue sauce on the sensors of a robot would be seen as like an assault on a human? I hope not, right? And so I think that, developing this foundational, fundamental ontological divide between AI and robotics on the one hand, and humans, animal, the natural environment on the other, I think is going to be quite important into the future, because there are so many corporations that can make so much money by, say, convincing us that a bot can be like a friend, a boyfriend or a girlfriend, or a bot should be like treated as we would treat a person or something. So it's going to be hard to resist, but I hope that we can draw those lines. So thanks.
Thank you. Sure, I wouldn't want to see a future where robots have a right to connect while we're trying to disconnect, right? So I can certainly see how that confuses things. And to Sushma's earlier point, I mean, whose perspectives are we centering and privileging here? I think is a really important question that we continue to go back to. So we're just about out of time, but I want to thank you all so much for participating. It's been a real pleasure to have you here, and we'd love to have you back in the future.